I'm asking you very nicely.
Yeah, that's good.
Back off. They're providing it to me.
But who are you going to provide my stuff to?
I'm providing it to your social media.
Sir, I'm going to ask you nicely. I will not divulge personal information. I am asking you to step away.
It begins not with flashing lights or a show of force, but with something far more dangerous: casual confidence. A police officer walks up to a man on a public sidewalk and, in response to being recorded, slowly, deliberately, and without hesitation, and most importantly, without justification, recites his full legal name and date of birth aloud. She does so with clarity, with intent, and crucially, with the awareness of body cams and smartphone cameras alike. This wasn't just an encounter, it was premeditated exposure. The moment that name hit the airwaves, a line was crossed. Not just ethically, not just professionally, but legally. Because this wasn't just a matter of disrespect, it was a targeted release of private information. And the officer delivering it wasn't caught in a moment of anger or confusion. She was calm, collected, and calculated. Let's pause and examine what actually happened here. At approximately 0 minutes and 2 seconds, the officer, referred to in documentation as Officer Jane Doe, makes the choice to threaten a passive civilian with the release of confidential personal data. She frames the threat as a form of response, a kind of tit-for-tat aimed at curbing the man's right to film a public scene. And moments later, she follows through. First name, middle, last, full date of birth, the kind of data that forms the foundation of identity theft, the kind of data shielded, in theory, by layers of state and federal protection. And she did it because he was recording. That's where the gravity deepens. This wasn't an accidental release. It was retribution. It brings us into the realm of 42 U.S. Code, R. 1983, a law that explicitly allows private citizens to sue government actors, including police officers, when they violate constitutional or federally protected rights under the color of law. The phrase color of law refers to actions taken under the appearance of legal authority. And what we see here is precisely that. An officer cloaking herself in departmental legitimacy to carry out an act of intimidation and exposure purely for personal dominance. Consider the implications. Imagine if this wasn't caught on video, if body cams weren't rolling, if the officer's actions weren't broadcast and preserved on multiple devices. This would be pushed into he said, she said territory, and the risk for public accountability would drop to zero. But it was recorded, and it opens the door to an undeniable legal trail. Federal privacy violations come into conversation quickly, because beyond FAR to 1983, there's something far sharper at play. The Computer Fraud and Abuse Act, 18 U.S. Code, Bars 130. If the officer retrieved this personal information using internal law enforcement databases, systems restricted to professional investigations and active policing, she may have committed a federal crime. Not a mistake, not a breach of protocol, a felony. And what's crucial here is that intent is on full display. She says, out loud, that the information will be posted to the man's social media, indicating that this was not done as part of an active investigation or for safety or even by accident. It was retaliation. This flips the standard narrative, one that is used by many officers when incidents spiral, that things escalated unintentionally. Here, we have clarity of thought and purpose from the first frame. The man does what countless others across the country have done. He stands on a public sidewalk and films police activity, peacefully and without disruptiveness. Recording police in public has long been recognized as a constitutionally protected First Amendment right, backed by precedent from cases like Glick v. Cuniff, 2011. and Fordyce v. City of Seattle, 1995. Put simply, if you can see it from the street, you can film it. But here's the turning point. When that protected behavior is responded to with targeted exposure, it becomes a civil rights issue. The same way physical retaliation would violate the Fourth Amendment. Digital or personal doxing constitutes a form of specific retaliatory harm. In moments like this, we look to law to draw lines. The Pond Drivers Privacy Protection Act, DPPA. A federal statute under 18 U.S.C. Secretary 2721 protects citizens' personal information from being disclosed or misused by DMV employees and law enforcement unless it is for a legitimate governmental function. Sharing a person's name and birth date with others, especially with an intent to broadcast, is not a legitimate purpose, and under the DPPA is potentially a criminal offense. But officers increasingly rely on a thin shield: qualified immunity. That legal concept, often criticized and actively debated within constitutional and civil litigation circles, protects officers from personal liability unless they have violated a clearly established right. For years, this doctrine has provided a near impenetrable legal defense for even egregious violations, so long as no prior case has ruled a similar action unconstitutional. This trend is rapidly shifting. In recent decisions, especially in cases involving data misuse, courts are now examining more closely whether an action was obviously wrong, regardless of novelty. Because no department policy in the U.S. allows officers to release private information about citizens in retaliation for protected filming. None. The law may not specify this in exact language, but the principle of privacy and data integrity is long established across federal law, judicial precedent, administrative codes, and departmental policy. What Officer Doe did was not a gray area. It was a black and white misuse of law enforcement power. Think about the weight of those numbers she spoke, the identity they represent. Birth dates are used in banking verification, in accessing health care, government services, employment screens. Sharing that information, in direct response to a constitutionally protected act, is not just unethical. It renders the target vulnerable. And yet, what accompanies this misuse? Bold certainty, no hesitation, no attempt to hide the act. Because Officer Doe doesn't just commit the violation, she taunts the victim with it, suggesting that she'll post it publicly, that she'll spread it, that she owns his privacy. The question becomes, why? What compels an officer sworn to uphold citizen protections to treat that information so casually and so punitively? In parts 2 and 3, we'll explore that question not just in prosecution terms, but in the psychology of power. When credentials become weapons, when access becomes threat, when an officer knows she can cross a line and assumes no system will truly stop her. But here's where the shift begins. The law is catching up. Citizens are recording. And these cameras, once seen as tools of passive observation, are becoming witnesses to weaponized authority. This case is no longer about a single officer. It's about the line between power and privacy, and what happens when that line is crossed so cleanly that retribution becomes the video title. In Part 2, we investigate the systems that allow this to happen. Databases, department culture, policy blind spots, and how the doctrine of qualified immunity could be unraveled by one officer's openly recorded act of retaliation. By now, the body cam has captured something undeniable. Personal information was intentionally disclosed. The officer's words were not garbled under stress, nor spoken impulsively in chaos. They were delivered clearly, deliberately, and with one aim: to intimidate a civilian who was legally recording the police. But what allows this to happen in the first place? How is it that a sworn officer with years of training, held to policy, protected by legal doctrine, empowered by badge and uniform, can weaponize a police database in broad daylight without hesitation? To answer that, we must examine the structure, because the abuse seen in this video is not an outlier. It's a symptom, a ripple from a much larger institutional problem. The misuse of authority embedded not just in behavior, but in access and assumption. Let's begin with the data itself. How did Officer Jane Doe obtain that man's name and birth date? She didn't guess. She didn't ask. She pulled it. Access to information of that kind doesn't come by accident. It requires a key law enforcement database query, almost always executed through state-run platforms that house driver's license records, registry details, and criminal history systems, variably named NCIC, CJIS, David, or CAD systems depending on jurisdiction. In Florida, where this encounter unfolds, the system is known as David, Driver and Vehicle Information Database. It's rigorously protected. Officers are taught in training that access is only to be used for official use only, which excludes curiosity, grudges, and retaliatory impulses. Misuse of David has led to disciplinary action across the state in the past, from demotions to firings to full criminal charges. So, if the legal framework already exists to punish misuse, why do violations like this happen so freely? The truth is, confidence and culture. From the first frame, Officer Doe appears completely unbothered by the legal risks of her conduct. Why? Because she doesn't believe she'll be held accountable. In departments across the country, database misuse is often treated as an internal affairs matter, not a crime. Suspensions are handed down quietly. Access is restored months later. Complaints are labeled policy violations, not criminal breaches. Unions provide insulation. And unless the footage goes viral or results in a lawsuit, there is usually no independent scrutiny. Let's be clear on what's at stake here. The name spoken, the date of birth, those identifiers are not benign. They are the root keys to a person's digital identity. They unlock access to credit pulls, background checks, and social security documents. Speak them loud enough, and they follow someone for years. Attach them to a name online during a public filming. You have doxed someone under the color of law. And yet, Officer Doe acts casually, because the system quietly teaches that personal information is just another lever of control. Now think about the context. The man she was targeting was filming from public property, a constitutionally protected act. There was no indication of a crime. No aggressive behavior, no interference in police duties. This footage captures a citizen engaged in a lawful First Amendment protected activity, being punished solely for doing so. This introduces a dangerous collision between access and attitude, when law enforcement officers begin to view public scrutiny not as their duty to tolerate, but as their justification to retaliate. Here's where things pivot toward systemic failure. Access to data is a trust. Officers are granted clearance, others aren't because they have a legal reason to look, and because they represent the impartial protector of due process. Every login carries audit trails, records of who queried what and when. But in many agencies, those logs are barely reviewed unless a complaint prompts an investigation, which means violations fester quietly, only becoming issues once a citizen can show evidence, press charges, or win civil traction. How many more citizens have had their information accessed without their knowledge? How many others were retaliated against without rolling cameras? Statistically, we don't even know. But Florida has an established history of these abuses.